Hello all, welcome to the second video on media law. The questions here discussed are these 5 questions. Let us directly go into the subject. Judgments of Supreme Court necessitated amendments of Constitution. Supreme Court. The Supreme Court of India is the highest constitutional court of the country which can be accessed directly by a citizen under Article 32 of Constitution for redress of fundamental rights. Commencing with 8 judges, the sanctioned strength of the court presently stands at 34. The Great versus Landmark Judgment. A great judgment is one that restores constitutional values of a polity from the waywardness into which it may have fallen. A landmark judgment is one which opens up new directions in our constitutional thinking and in the process adds new dimensions to what are regarded as established constitutional principles. If great restores the centrality of constitutional values, landmark revitalizes them. Coming to landmark judgments discussed here are regarding personal liberty, procedure established by law, A.K. Gopalan versus State of Madras. Likewise, I'll discuss each case. Regarding personal liberty, the procedure established by law, the landmark judgment is A.K. Gopalan versus State of Madras, 1950, Supreme Court, Record 88. The facts in this case are the petitioner detained under the Preventive Detention Act challenged the legality of Detention Act under Article 32 of the Constitution on the ground that the said article contravened Articles 13, 19, 21 and 22 of Constitution and was therefore ultra vires. The Supreme Court held that Article 22 was a self-contained code and if personal liberty is taken away by the state in accordance with the procedure established by law, that is, if the detention was as per the procedure established by law, then it cannot be said that the law was violative of provisions contained in Articles 14, 19 and 21 of the Constitution. Amendability of fundamental rights. Shankari Prasad versus Union of India, 1952. This case dealt with amendability of fundamental rights, that is, the First Amendment's validity was challenged. The Supreme Court held that the power conferred on Parliament by Article 368 to amend is a very wide power and includes the power to take away the fundamental rights guaranteed by Part 3, and that in the context of Article 13, Clause 2, law must be taken to mean rules or regulations made in an exercise of ordinary legislative power and not amendments to the Constitution made in the exercise of constituent power. In the result, with the result that Article 13, Clause 2 does not affect amendments made under Article 368. This view was reiterated in Sajjan Singh versus State of Rajasthan, 1965. The doctrine of basic structure. His Holiness Keshavananda Bharati Sripada Galavaru versus State of Kerala, famously known as Keshavananda Bharati case, 1973, the most celebrated case in the history of Indian constitutional law, in which the apex court dealt with the issue whether the parliament can amend any part of the constitution and what was the limit to that power. The bench, by a majority of 7-6, overruled the proposition of law propounded in I.C. Golaknath versus State of Punjab, 1967, and held that constitutional amendment is not law within the meaning of Article 13, and that although no part of the Constitution, including Part 3, comprising of fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by the constitutional amendment. As regards the basic structure, the court held that it would be decided from the case-to-case basis. Doctrine of basic structure and its application is dealt in case of Indira Nehru Gandhi versus Raj Narayan, 1975. The validity of 39th Constitution Amendment enacted in 1975, which is Article 39A, sought to place the election of the President, Vice President, the Prime Minister and the Speaker of Lok Sabha beyond the scrutiny of the constitutional courts, was challenged in this case. The Supreme Court, reporting to the theory of basic structure of the Constitution, struck down Clause 4 of Article 329A on the grounds that It was beyond the Parliament's amending power as it destroyed the basic structure of Constitution. The doctrine of basic structure dealt in Minerva Mill's case is the validity of Constitution 42nd Amendment Act 1976, which inter alia provided for exclusion of judicial review of constitutional amendments and expressly conferred unlimited amendment power to the Parliament, was challenged on the ground that they are violative of basic structure of Constitution. The court, by majority of 4 to 1, struck down clauses 4 and 5 of the Article 368, holding that they violated the basic structure of the Constitution. The court ruled that Parliament's power to make constitutional amendments is limited, which itself is a basic feature of the Constitution. The judgment makes it clear that the Constitution and not the Parliament is supreme. Human rights decriminalizing the homosexuality. The landmark judgment regarding this decriminalizing homosexuality is Navtej Singh Johar versus Union of India 2018. A five-judge Supreme Court bench gave a historic unanimous decision on Section 377 of Indian Penal Code decriminalizing homosexuality. The Supreme Court ruled that sexual orientation is an intrinsic element of liberty, dignity, privacy, individual autonomy, and equality, and that intimacy between consenting adults of the same sex is beyond the legitimate interests of the state. That insofar as Section 377 criminalizes consensual sexual acts of adults, that is, persons above the age of 18 years who are competent to consent in private, is violative of Articles 14, 15, 19, and 21 of the Constitution. Let us see the next topic, RTA Act, which is given as an overview on the RTA Act. Any question on RTA Act, you can write from these slides. Introduction. Every citizen of India has a right to freedom of speech and expression under Article 19(1)(a) of the Constitution of India. The right does not only cover the communication of information but also the receipt of information, since without adequate information, a person cannot form an informed opinion. The Honorable Supreme Court has also held that the right of the citizens to know and to receive information regarding matters of public concern is a fundamental right flowing from Article 19(1)(a). Most of the topics in media law you can mention Article 19(1)(a) and Article 19(2). Everywhere it is given in the textbook. Background: the Freedom of Information Act 2002, amended by National Advisory Council, known as the Right to Information Act 2005, was passed on 11th May 2005 and 12th May 2005 by Lok Sabha and Rajya Sabha respectively. The President of India gave his assent to the Act on 15th June 2005 and it came into force in 12th October 2005. You need to remember Freedom of Information Act 2002 was first is the origin, and this was amended by National Advisory Council, and the Right to Information Act 2005 was established. Objectives of Right to Information Act 2005 are as follows: to provide for a practical framework that allows the citizens to access the information under the control of public authorities, to promote transparency and accountability in working of governments and their instrumentalities, to provide for constitution of information commissions at state and national level for discharging the functions and exercising the powers under the Act, to develop an informed citizenry, to contain corruption, to lay down the exemptions to disclosure of information when such disclosure is likely to conflict with other public interests, and to harmonize these conflicting interests while preserving the paramountcy of the democratic ideal. Right to Information Act is defined under Section 2, Clause J. Section 2J defines right to information. It means the right to obtain the information accessible under the RTA Act, which is held by or is under the control of any public authority. Such right includes right of inspection, that is, right to look and scrutinize closely the documents, works, and records. Here, it is seen on scrutinized only. Right to take notes and extracts, right to take certified samples of materials, right to obtain information in electronic mode. Features of the RTI Act 2005. Public authorities have a duty to provide any information which is claimed by citizen. Public authorities are under the obligation that they need to circulate the information to the person who demands the information. Here, this act comes with a certain obligations relating to the scrutiny of the nation, personal information, and other persons' information. There is a time limit on the authority to give information within 30 days. If the authority denies providing any kind of information, then the person has the power to go to the appellate authority. Later, they can also go to the second appeal, which falls under the Central Information Commission or State Information Commission. Local court commands cannot be entertained in these scenarios. Exceptions, exemptions from disclosure. And in nutshell, it is I am giving this, which is dealt under Section 8. In the previous first video on medical law, I have given elaborately. It is also given under Right to Information Act 2005, which are as follows. The information which tends to prejudice the international relationship, integrity, and national security of the country. The information which is expressly forbidden from disclosure by tribunals and court. The information which related personal details and not in the interest of the public, and if there is access to information, it may violate the right to privacy. Information related to trade secrets, commercially confidential information, and intellectual property. Confidential information received from foreign government, etc. Coming to case laws. In the case of Bennett Coleman versus Union of India, the apex court stated that right to information is our fundamental right, falls within the purview of Article 19(1)(a) of the Constitution of India. In the case of S.P. Gupta versus Union of India, the court observed that it is a right of the public to get information regarding public functions performed by the public authorities and authorize public to access the information related to public transactions performed within the scope of the Public Act. In the case of People's Union of Civil Liberties versus Union of India, the apex court analyzed right to information in the light of human rights, which is requisite for making administration and governance accountable and more transparent. Therefore, from the above observations of the Supreme Court, we can say that right to information is our fundamental right. Obscenity. The next question is obscenity acts as a limitation on the freedom of speech and expression. Coming to introduction. One of the basic fundamental rights that any human being will acquire on their birth is the freedom of speech and expression. It is by virtue of this right that every person has the liberty to express themselves and to convey their thoughts, speech, and feelings. The spirit of this fundamental right has been guaranteed under Article 19 in Part 3 of the Constitution. Limitation on Article 19. Man, as a rational being, has desires, and in order to continue living in a civil society, these desires and wishes are put under limitations and restrictions. These constraints are important as they serve the interest of the public and are enforced for their welfare only. Thus, certain reasonable restrictions are specified under Article 19(2) of Constitution, which restrict the right to freedom of speech and expression and curtail it from being an absolute right. In order to strike a balance between individual liberty and public good, various steps are taken by the Indian government at both national and state level. What is obscenity? When we talk about obscenity under the Indian law, the definition can be summarized as follows. Anything having a primary appeal to lustful or voyeuristic tendencies, any work, literacy, artistic or otherwise, that offensively in a very clear way shows or outlines sexual conduct. In legal terms, obscenity can be defined as an indecent expression which could be displayed through words, actions, or gestures. The concept of obscenity is usually considered synonymous with pornography, and thus the word obscene is used interchangeably with the word porn. Obscenity, media, and the freedom of expression. There has been circumstances where people form an opinion that some materials are against the cultural values of the society, and then such materials are placed within the bracket of obscenity. Events from the immediate past have shown how writers, actors, and painters face prosecution on the charges of propagating the alleged obscene materials. With the growth of mass media over the last few decades, it is of the utmost importance to have clear vision of what forms a prohibited act. Statutory provisions on obscenity. Under the Indian Penal Code 1860, Section 292 to 294 to 294 prohibit publication and selling of obscene materials, but at the same time, indecent representation of women does not fall under the ambit of the said sections. Often, women are portrayed in very derogatory, indecent, and obscene light. They are reduced to merely becoming an object of lust, and this leads to their victimization in the society and consequential corruption. Indecent Representation of Women Prohibition Act 1986. It is introduced to outlaw the indecent, improper, and scandalous depiction of women through any kind of publications, writings, paintings, advertisements, etc. Obscenity under Indian Penal Code 1860. Indian Penal Code 1860 discusses obscenity under Section 92 to 290, under Section 292 to 294. Section 292 penalizes the offence of obscenity. The clause 1 of a section lays a list of materials which would be deemed as obscene if it strikes at the lascivious, voyeuristic, salacious, or lustful interest of a person and consequently deprives or corrupts a person in sexual context. Section 293 of the Code provides for punishment and imprisonment or fine for anyone who promotes, sells, possesses, hires, distributes, imports, exports, purchases, or makes profit out of anything which can be categorized under the definition of obscene materials. Section 294 IBC also penalizes with regard to obscene songs and acts. Laws violative Article 19. The above laid offences against obscenity as defined under the Penal Code are curtailing an individual's freedom to express himself. Hence, they are said to be in clear conflict with the Article 19 of the Constitution of India, as it is often misused and manipulated into restricting a citizen from exercising their right to freedom of expression. Coming to case laws, the famous case law K.A. Abbas versus Union of India, which I discussed in the previous video. A film was contended to be objectionable. The movie depicted the contrasting lives of the urban and poor people. Some part of the film dealt with the life of the prostitutes of Bombay. The censor board rejected the petition of granting U certificate to the movie. When the petitioner approached the central government appellate authority for the same, it agreed to grant U certificate subject to a condition that certain scenes, specifically the prostitution part, to be removed. Thereafter, the petitioner moved to the Supreme Court under the Article 32 for violative of his fundamental rights. The judgment given had many references to the American jurisprudence on the obscenity. It was observed by the court that two terms of sex and obscenity are not always synonymous, and it is wrong that merely the mention of the word sex is classified as essentially obscene or even indecent or immoral. The second case, as discussed in the previous video, the banning of movies Bandit Queen by Delhi High Court in the case of Bobby 21 Art International versus Om Pal Singh Hoon is yet another example in the matter of issue on the matter in this issue. This judgment was challenged in Supreme Court. An expert tribunal consisting of 3 female members rendering a decision giving a certificate to the movie, clearly showing their opinion that women are not be degraded, insulted, or shown as a medium to depict pornography. Coming to the next topic, explain how television is useful for developmental purposes. This is a very vague and general topic where everyone can write whatever they wish to write in the exam. But I have given some of the some of the points which you can write, which you can get good impression. Television has played a vital role in the development of the society. Television has changed the societies of the world so much that one cannot ignore its importance. Television today has become an important part of every house. It is the source of information, entertainment, and education. Television in transmitting cultural values. Television has been able to shape cultural and public opinion. Television is shaping the food habits, cultural values, social mores, and what not of the society in a manner no other medium has done so far, said the Supreme Court in the landmark judgment of Airwaves. Coming to this, the regulation of television is needed. One of the major reasons attributed to the growth in TV sets in India in all over country since 2010 is the increasing number of nuclear families without elders than ever before. Given the low levels of literacy in India in rural India in particular and rural India in particular, the excess influence of TV has to be regulated. Unlike the movies, where the demand side, that is, the audience is filtered before entering into the movie hall. So such mechanisms exist in case of television. No such mechanisms exist in the case of television. Hence, there is a need to filter the supply side, that is, the content before it can be transmitted. Impact of television on society. Television has brought changes in the way people receive information and understand it. Research shows that perception of the television messages, ideas, and images shape the entire social system. Television has created awareness and appreciation of social cultural development. For any social change, the flow of information is an important part. It will increase the understanding of the people regarding the issue and develop feelings for the need for social change. Information in the is the bridge that helps understand and unite for the cause. You can remove the word television and keep visual media in wherever you get an essay on visual media. We use television for everything. It has everything: news, politics, literature, music, e commerce. Our lives depend on the television. Television images have great power. They are changing our minds, feelings, ways of thinking, and the way we relate with people in the world. Human societies have changed since television became part of people's life. Television and value system. Television is one of the important factors in the development of attitudes, values, and behaviors. It is a social educator helping to shape social, emotional, and physical development. It plays a strong role in the transformation of culture, values, and norms in a society. It is emerging as a powerful tool in shaping the social values in light of what we see on television. Socio-cultural development. The socio-cultural is used to describe the difference between people based on the social class and culture which they live in. Television has played a major role in the development of socio-cultural factors such as customs, lifestyles, and values. It had made people aware of cultural aspects. Television played an important role in promoting aesthetics, education, language, law, religion, politics, technology, and material culture. Positive effects of television on society. Television has great influence on our daily life and it plays a vital role in the transformation and shaping people's union. Now, the documentaries and programs about the social issues are creating awareness among the people and it is developing their concerns towards the society and culture. The role of females was that they should stay at home as a housewife only. This was traditional heritage and typical role of women. But television has changed this idea. Now they can work and are also portrayed as working ladies. The girls in rural areas were not allowed to study, but television has changed the ideas of people. Now the girls are sent for education easily, both in rural areas and urban areas. Television is also pointing out many social issues like dowry, child marriage, drug abuse, child abuse, and other social problems in society. With the help of television, one can learn about different cultures and their values. This promotes mutual understanding and helps connect the people of different cultural backgrounds. It helps in cultural exchange. Negative effects of television. Television promotes artificial demands, unnecessary desires and wants. Television makes use of the psychology of children, women and aged people. Advertising appeals primarily to our emotions rather than intellect. Television has resulted in a particular lifestyle of pomp and show. Regulation of contents of television. New no non-news and current affairs TV channels. In the In the contents of non-news and current affairs TV channels, the content or programs on these channels are regulated by Cable Television Networks Regulation Act 1995, which consists of a program code and the advertising code. On the news and current affairs of TV channels, there is no statutory regulatory mechanism, and the news and the current affairs TV channels in India are regulated by self-regulatory body known as News Broadcasters Association, which has formulated a standards code known as NBA code. There is no statutory provision or body to regulate the ad content in India. Hence, self-governing body called the Advertising Standards Council of India has been formed to regulate the ad content in India. Sorry, it is repeated. Films on television. The Cinematograph Act 1952 provides for the establishment of a Central Board of Film Certification CBFC, which has to certify films for public exhibition. Exhibition of any film without the certificate of CBFC is illegal. Any content awarded an A certificate cannot be aired on TV. Prasar Bharati Act 1990. Broadcasting Corporation of India, properly known as the Prasar Bharati, established under the Prasar Bharati Act 1990. The primary aim of the Prasar Bharati is to conduct public broadcasting services to inform, educate, entertain the public and to ensure a balanced development of broadcasting on TV. Freedom of press. This is discussed under the following headings. Introduction. What is freedom of press? History. Grounds of restriction and constitution. Fourth pillar of democracy and respective case laws. Introduction. In the world of largest democracy, the freedom of speech and expression is the most crucial fundamental right availed to the citizens by constitution. The media is considered as the fourth pillar of democracy and it plays a vital role in a country's social, political, economical and international affairs. Thus, the free press is a sine qua non for the democracy to survive and thrive and preserve the ethos of good and transparent governance. Freedom of press. The term freedom of press refers to the government's minimal interference in the operation of the press in any form of communication, including print. That under print you get newspapers, magazines, journals, and reports, and audio, that is radio and postcards, videos, news channels, OTT platforms like YouTube, and other electronic mediums such as news apps, social media feeds, and so on. Thus, it is concluded that freedom of press refers to the ability to say whatever one wants without seeking permission from the government. History. The media laws in India have a long history and are deeply rooted in the country's colonial experience under British rule. The earliest regulatory measures can be traced back to 1799, where the Lord Wellesley promulgated the press regulations, which had the effect of imposing free censorship on an infant newspaper publishing industry. The onset of 1835 saw the promulgation of the Press Act, which undid most of the repressive features of earlier regulations on the subject. Thereafter, on 18th June 1857, the government passed the Gagging Act, which, among various other things, introduced compulsory licensing for owning or running of printing presses, empowered the government to prohibit the publication which had a tendency to cause an outbreak against the government, thereby weakening its authority. Although the Indian Constitution does not expressly mention the liberty of press, it is evident that the liberty of press is included in the freedom of speech and expression under Article 19(1)(a). It is, however, pertinent to mention that such freedom is not absolute but is qualified by certain clearly defined limitations under Article 19(2) in the interests of the public. Freedom of press and Article 19(1)(a). Freedom of press is implicit under the Article 19(1)(a) of the Indian Constitution, which provides for the freedom of speech and expression under Part 3, Fundamental Rights. It does not explicitly provide the term freedom of press anywhere, but Dr. B.R. Ambedkar replied in Constitution Assembly debate to a question of Article 19 not including freedom of press, saying that the press is just another method of quoting an individual citizen, and when anyone chooses to write in newspaper, they are merely exercising their right of expression, and thus there is absolutely no need to separately mention the freedom of the press. Scope of freedom. The scope of freedom of press under Article 19(1)(a) is freedom to spread information, freedom to criticize, freedom to receive the information, freedom to conduct interview, freedom to report court proceedings, freedom to attend report legislative proceedings, freedom to act as an advertising platform, freedom to broadcast. Grounds of restriction. As freedom press derives its powers from Article 19(1)(a), it is also subject to reasonable limitations imposed on Article 19(1)(a) and Article 19(2), which are explained as follows. Sovereignty and integrity of the state. As at this juncture, it is essential to take cognizance of the fact that sedition is no ground to impose reasonable restrictions as envisaged under Article 92 of 9(2) of the Constitution. Security of the state. Any communication which incites the people to cause social unrest, rebels, violence, riots, etc. against the state and its subjects would be covered under this restriction. Public order. This term was inserted by the Constitution First Amendment Act 1951. This clause was added to curtail the effects of Ramesh Thapar versus State of Madras, famously known as Thapar's case, where the Supreme Court had held that the right to circulation is an intrinsic organ of right to freedom of expression. Decency and morality. In Ranjit Udeshi versus State of Maharashtra, Supreme Court held that Section 292 of IPC is constitutional as it prohibits obscenity in public places and promulgates public decency and morality. Further elaboration of this ground is reflected in Section 292 to 294 of the IPC. Contempt of court. Supreme Court under Article 129 and the High Courts under Article 215 of the Constitution is empowered to take punitive actions for contempt of court. Contempt of court is Article 129 and Article 215 of the Constitution. It is further held in C.K. Daftare versus O.P. Gupta. It was held that the Section 228 of IPC and Article 129 of the Constitution are valid and are covered within the purview of the reasonable restrictions enshrined in Article 19, Clause 2 of the Constitution. Defamation. No one is allowed to expose a person to hate, ridicule, or contempt by means of any expression, signs, or gestures. Defamation is considered as a very stringent act and therefore it is prohibited by civil laws or torts. It is an offence under Section 499 of IPC. As something is enshrined as wrong under two states, it is obvious that it has a defense under reasonable restrictions of Article 19, Clause 2 of the Constitution. Fourth pillar of democracy. Speaking of democracy, political scientists and experts always say there are four pillars of democracy, namely the judiciary, executive, legislative, and media. The three pillars of democracy are judiciary, legislation, and executive. Media is an important and inseparable part of the democratic society. It is in fact called the fourth pillar of democracy because oftentimes people assume that the media is more neutral and free from elements of state power in contrast with the previous three pillars which are all oriented to power. The media not only as a source of news but it also the voice of the people, career and fittings. The media also often became a tool for suppressing the three pillars of the democracy. Thank you. Please like, share, subscribe and comment.